Let me type my phone number while you all are coming in. How's everyone doing? 1037 or what's up? Come on in, guys. I'm just trying to put in this phone numbers. Good morning, Jagante. All right, let's pin it. Good morning, everyone. If you're on Instagram, good morning. My number is pinned right there for you. If you're on Facebook or YouTube, you can see my number scrolling through the ticker. Welcome. If this is your first time tuning in, welcome. My name is Aisha Chidole, and I'm an attorney. I'm an immigration attorney. I represent clients in all 50 states with their immigration cases here in the United States, family immigration, humanitarian-based cases, consular processing, and what else do we do? Removal cases and some detention work. If you'd like to schedule a consultation, definitely give us a call. Our number is 678-325-1037. You can also call 678-233-2170. And you can also send a WhatsApp to 404-333-8751. Our number is pinned on Instagram. It's also scrolling through the ticker on Facebook and YouTube. To schedule a consultation about your own particular case. Yes, it's been, I saw someone saying it's been a heck of a week. I mean, yeah, it has. So let's chat, guys. If you didn't tune into my live yesterday, you should probably watch that. If you have questions about the new USCIS policy memo and how that might impact your case, who are the exceptions, or who are the exceptions that are written in the memo, what does it include, what does it entail? Obviously, as each day passes, we get more intel. So, I want to talk about that. So what we're seeing is, I had read to you guys like an RFE, request for additional evidence, that somebody got, when it happened. So I've also seen or have heard from a few attorneys who have had interviews since, the new memo passed. And, there seems to be a focus on 4 questions in particular. Some attorneys have said that during the interviews went as normal, like they didn't ask them any new question related to consular processing. So it'd be interesting to see how they apply that. But, historically, USCIS offices have never all operated the same exact way. So I'll go over those 4 questions in a second. Someone is saying, the new update, does it affect someone that's been here for 15 years waiting on a green card? So it doesn't matter how long you've been here. It depends on what kind of green card application that you've applied for. Again, let me repeat it. This new update primarily affects those who are here, who came here either inspected, admitted, or paroled on a temporary basis, and overstayed and applying for a green card. So typically that would be people applying for either a family-based green card or an employment-based green card. Like, if you came here on a B1, B2, F1, J1, so things like that. What it is that they're looking for and what it seems clear that they're looking for are people who have economic impact in the United States, people who are contributing to the United States. Again, I talked about this last year. I talked about this in the fall of 2024, how, once this administration changes, that it will, that I expect them to bring something back like they did in the previous Trump administration, which was the wealth test. They called it the public charge rule, but most people refer to it as a well test because they were testing for certain things. And based on the RFE, where they're asking about, your educational background, hardship, fluency in English, employment, evidence of community service, it's clear that this is kind of like a more refined version of it without necessarily changing the forms that you use. Because in the past, you had to do an additional form called the I-944. Now it's still a 485 as far as we know, but this is what they're doing. For those who had interviews already scheduled, I guess this week, a few people have said the questions that they're asked is, why did you apply for adjustment of status instead of consular processing? Are there any factors that will prevent you from pursuing consular processing? Do you have family still living there, like wherever your consulate is or your home country is? And why did you decide not to return to your country when your period of authorized stay expired? This last question has been asked this entire year. Before this announcement, every interview I've gone to or every client I've spoken with before they attended the interview, we've gone over this because this is a question that has been asked. So, the other three questions are newer questions based on this memo. So you need to be able to answer that. But honestly, if you are attending your interview, like there's no point of going without presenting positive equities that makes this case or this case favorable to you. Like I said yesterday, if you're a client, then you don't have to worry because we will prepare that with you. So that can be presented at the interview and making sure that you're able to articulate yourself, at the interview to explain why. For a lot of people, especially people from the 39 countries that have a ban outside of the United States or have a 75-year pause out of the United States, and some of them overlap, like certain countries overlap with the two, it is virtually impracticable and impossible for them to consular process. So that is one of the things that should be at the forefront when you are presenting your equities of why you cannot consular process, because for a lot of people, it means an indefinite or never reunification with your family members here in the United States. For other people, you're looking at a 10-year plus bar, meaning that you'll be away from your family for 10. So there are many arguments that can be made. Please understand that, guys, discretion has always been something that USCIS officers have to give. Almost all of us attorneys believe that this memo is misconstruing what Congress intended. And so there are lawsuits that have already been filed. We'll see what the outcome of those are. But until that, my focus, for our clients and for you guys should be to prepare your application to explain why you should get this. It is the same way that if you're applying for a 601 waiver for misrepresentation, you want to explain why you should get that hardship waiver. It is the same way, it's the same way that if you're applying for a trafficking visa, you have to explain why you were trafficked and why you would experience hardship. It's the same way that if you're applying for valid claims, that you have to explain why, you've been a victim of abuse. It's the same way with the U visa, you have to explain why you've been a victim of a serious crime and why you deserve this. So, explaining why you deserve something is not new. At least for those of us who practice. Maybe for those of you who have thought, well, with a marriage-based case, all I have to show is I have a good faith marriage. I don't need to explain anything else, which really is what Congress intended when, they kind of created it. But because this is now kind of the new modus operandi, you just have to be prepared for it. All right. And I've seen a couple of people asking, does this apply to fiancé visas or K-1 visas? No, it does not. That visa is intended to be done in the United States. That's not a consular application. It's literally intended for you to enter into the United States and adjust your status into the United States. Some people have asked about VAWAs, T's and U's. If you have an approved T, trafficking, U, serious crime, or VAWA for abuse, or asylee, like you've been approved for those are some of the categories that the USCIS spokesperson said that they want to focus on that. So those, appear to be exempt from that. But even still with that, I think it's still important to just kind of show and explain why you would experience hardship, if you had to do it anywhere else, Obi Tibbs from Tampa. Obioma, how are you? Longest time. I hope everything is well with you. All right, let me take some of y'all's questions. Thanks for everything you do for us. God bless you and your family. Thank you. I appreciate it. Does this new law go for those who came on a J1 and filed for VAWA and still waiting for approval? Again, I just literally talked about this right now. Right now, humanitarian visas should be okay. If you have an approved humanitarian visa, this is really focused on people who came here on a temporary visa, and applying for like a marriage-based adjustment of status, family-based adjustment of status, employment-based adjustment of status. Someone is asking, is there any update on the visa pause? There is no update right now. I mean, you would think that with this, you want people to consular process, then give us an update and remove the pause so people can actually consular process, but there is no update on that. So if you ask me that same question on Instagram, I would ignore the question just because I just answered it. There is no update on any of the consular processing pauses or bans yet outside of the US. Okay. All right. Let's see. What else y'all got? Why was VAWA processing time extended recently? I don't know. You would have to ask USCIS that. But right now, you can fully expect every case type, almost every case type, takes some time because of the additional vetting and extreme vetting that USCIS is doing. There's been an influx of alleged fraudulent VAWA cases that have been submitted, and so for USCIS, they are. One second, guys. Let me decline this call. So for USCIS, they are taking more time to review these files, and for a lot of people, they're now getting they're now getting interviews. Like some of them are getting interviews. So some VAWA cases are getting interviews. So all those things take time, but every case type, honestly, we're seeing them taking time, because what USCIS is doing is that they'll create something, they'll pause, they'll open, they'll pause, and stuff like that. Okay. Someone is asking, please, you keep saying approved VAWA cases are exempted. Does that mean pending VAWA cases are not exempted? No, Ishmael, that's not what it means. You cannot get a green card without your VAWA case being approved. So that's why I'm saying approved VAWA cases. There's never been a time that you can get a green card without an approved VAWA. So even if you file for VAWA, your VAWA has to be approved in order for you to get a green card. So there's no point of saying pending VAWA, because there's no such thing as pending VAWA getting a green card. Your VAWA case has to be approved in order for them to approve your 485. When you file for VAWA, you file an I-360 and you file a 485. The I-360 must be approved before you get a 485 approval, which is a green card. Same with the marriage case. If you file a marriage case, if your I-130 is not approved, and it continues to remain pending, you cannot get a green card on the 485. So don't worry about the semantics of pending versus approved. The bottom line is that if you have an adjustment of status, a 485 application based on a VAWA application, a T trafficking application based on an approved T, a U visa or asylee, because with those categories, you don't file simultaneously. Right? You have to, first of all, get the approval before you can even file the 485, VAWA being the only one that you can file simultaneously. I'm just stating to you that right now the language is saying that they want to focus more on reviewing those case types and letting the other people consular process. So please don't be bogged down by the semantics of it. Good morning. Can we expect an update for the immigrant visa pause after 180 days, which will be June? I honestly don't know. I don't know that the visa pause has 180 days where you can expect an update. I know that the visa ban said that they will review each country after 180 days. The visa ban is different from the visa pause. So there's 75 countries that have a visa pause based on public charge. Again, as you can see, kind of like a pattern here, a lot of this has to do with wealth and the law of economics, what people can contribute financially to the United States. For the pause, there's not necessarily 180 days. We're just kind of waiting for those outside of the United States. For the ban, what the language says is that every 180 days, they will review and decide if they're keeping anyone or adding more people to the list. So yes, June will be 180 days for those banned countries, and we'll see what happens. All right. Someone is saying, I want to hear about N400 naturalization. What exactly would you like to hear about that? Despite the new memo at the 39 country pause still in effect. Yes, they are. They are. Do you think it's safe to apply for adjustment of status right now? You should apply for adjustment of status if you are eligible for adjustment of status, and you should be prepared to explain why you should get favorable discretion, like any other immigration application. What is the alternative? That you have nothing that you file for, and then you're just sitting around or driving around as a passenger one day, and then you get picked up. We've seen that happen. We got a call yesterday with someone who was a passenger. The driver got stopped for speeding, and she didn't have her documentation and is in detention. So if you have a viable alternative that can stay a removal case, stay meaning pause a removal case, to allow them adjudicated, why wouldn't you file? If they tell you that you have to consular process, then fine, they should let you do your 601A. You get your 601A approved, and then you go, depending on if you have a qualifying relative or not. If you don't have a qualifying relative, then that's an argument to make why consular processing is not available for you. Remember, this rule is basically saying that you just basically have to explain why consular processing is not available to you. Right? So if you fall under one of the things that, I've mentioned today, you should be making that argument. I mean, maybe because I'm a lawyer, and so our job is automatically to argue why X should be Y. I can't imagine, carrying down. I mean, the whole point of the current administration is to discourage people from becoming green card holders and U.S. citizens. And so, but if you are eligible for it, why wouldn't you apply? It doesn't make any sense to me, but again, everybody has their own, issue in how, they deal with crises and things like that. If you answer a VAWA request for evidence from November, but no answer yet. Yes, we are seeing, again, VAWA cases that are really taking a long time. We have a lot of RFEs that we've responded to that we're also still waiting on because, like I said, the reviews are taking much longer than they typically would take. This is going to be, an exercise of patience. It's funny that some people don't want to file. You want to wait 2.5 years and somehow believe that things are going to change. You don't know who's going to be in office, 2.5 years from now. You don't know if this is going to be amplified, in the next 4 years. So when you are eligible for something, and that is a part where a lot of lawyers have been saying it to people and have been ringing the alarm. You guys know, I don't like to fear mong or be a sensationalist, or I don't have time for that. I'm dealing with a lot of stuff that I don't have time for that. But that said, we have been stating when you are eligible for something, you don't know when the policies will change, because that's the nature of immigration. It's like this. It's literally like this. Every day. And that's how it's always been. In some administrations, it's more changes than normal. But the thing is, when you're eligible for something, you should be applying for it, because certain rules are retroactive, certain rules are not. Meaning sometimes they will say, okay, this applies starting from X date. This applies starting from, for instance, the signature rule, right? So if, I don't know, let's say you're one of those people that your signature doesn't meet whatever the signature requirements were, or are currently, like this new signature rule, it's it starts in July or whatever it is. So for the people that filed before that, they would go based on the old signature rule. Or if you have a form and they change the form and they say this new form, starts on this date. So for those of you who submitted before, you're fine. So that's the nature of immigration. The nature of immigration is that, the rules change. And so you always want to file when you're eligible. Let me give you another anecdote, another example. Like, it's like, I think it was like 2019, 2018, 2020, we had LRIFA, like for Liberians. Many of them dilly-dallied. Those who were eligible filed and got their green card. Those who came after, I was like, sorry, the laws have changed. You're no longer eligible, because that was also during this current administration's administration 1.0. So again, it is not about sitting down and saying, should I wait 3 years? Because you don't know what's going to happen 3 years from now. So what you need to make sure you're doing is that you're consulting with an attorney to go over your immigration options. That's the first thing. What viability do you have in your case? Basically, you cannot make a decision based on Instagram, based on TikTok, and based on Facebook if you've not consulted with an attorney. If you consult an attorney can tell you whether or not you qualify for something and you should be filing for something. I do have people that come to consult that they believe that they qualify for something, and they come into a consult and we go through everything. And then I say, you don't qualify for anything right now. If any of the rules changed and make you eligible, I will put you in like an email cycle to let you know. But you know what? Those people leave those consultations knowing what their options are. But if you think that you might qualify for something, but you're like, all right, let me just hold on to my application and just pray, that somehow in the next 3 years or in the next 7 years, that all of this will die down. What is the plan? That's no way to live, okay. What if you have an approved VAWA case and waiting for a decision for a green card after interview was over 1 year now? So do you mean that you had an interview for your I-485? Is that what you mean? Yeah, if you had an interview for your I-485, and you're not from one of the countries with the pauses, I definitely think that you should be doing an inquiry now. Will marriage affect your N-400 application? That's a really vague question. I don't understand what you mean. You can be married or divorced with your naturalization application. You just have to indicate your correct marital status. And even after your interview, let's say you do an N-400 interview and they approve you for citizenship or for an oath ceremony, if before the oath ceremony you get divorced or you get married, you need to bring that certificate with you to the oath ceremony, because you want to make sure that your naturalization has your exact marriage status, whether that's divorce, widowed, married, or whatever it is. So there's no rule that says you cannot be married to become a United States citizen. Mr. Amazin says, good morning. What if I have a waived interview for the 485? What do you mean you have, what do you mean you have a waived interview? Because if you're looking at what it says on USCIS portal, I assure you that it's nonsense. There are many people that says waived and they get scheduled for an interview, my clients included. So if that's what you're talking about, just unless you have a green card in your hand, you could have one. Okay. What about people with approved VAWA cases and their adjustment of status has been in abeyance and is now in the process of review following the VAWA approval? Not sure what the question you're asking, but if it is in the process of review, you should expect an interview, and the interview will be going over your I-485 to make sure everything looks good on there. And if everything looks good on there, you will be approved for a green card, God willing. VAWA was approved last year, February 2024. RFE on the medical, November 2025. I responded back in 3 weeks. Now the case was transferred from field office to Vermont. Any clarity on this? So it was transferred to Vermont, or was the other way around? Vermont transferred it to a field office. You want to be sure about this because typically it's the other way around. It transfers it to the field office. That's typically how it works. And the field office are those that will do the interview. Tony, what is the situation of the U visa and VAL under the new immigration laws? I just answered this several times, guys. These are humanitarian cases which are, exempt right now from the requirement that you have to prove, favorable discretion for adjustment of status. Again, if you have a marriage-based case, it's not the end of the world. You can still adjust your status. If you're eligible to adjust your status. Again, the key is legal strategy. You have to be able to cite the laws that so when you look at USCIS's memo, this is a bit legalese. I generally try not to get into too much legalese, but let me get into it for a second. When you look at USCIS memo, USCIS has cited laws, like cited cases like matter of X or matter of Y, where this is what this person did and this is what the judge said. So like one of the things that we did, I was working late last night because I was like, these people are not going to let me do my work because every day I have to add a new brief, right? Like last night, I was literally working on finding the other laws that support our clients' cases and differentiating our clients' cases from those cases based on their own extenuating circumstances, because that is an argument that I plan to make on every single application. Before an RFE comes, like if your case has already been submitted, your arguments would be when you're going to your interview, they request additional evidence. But any case going forward now, whether we were ready to submit it, they're not being submitted until we add this new arguments, right? So that's just the thing. You just have to make sure that you're able to add those arguments that show your positives. What are the positive things about this person and why this person deserves this? I mean, it's the same way. Don't you guys remember like a couple of months ago when they said with the N-400, it's no longer just enough to not have a criminal record. Now you have to prove you're a person of good moral character. You got to prove this, prove that. These are our N-400 interviews have been going on the same way that they were going on before. This one, like I said, we've seen 4 new questions. You have to be able to just answer those 4 new questions. And if you get any kind of request for evidence, you have to be able to answer it. Remember, guys, that in order for them to deny you, one of the things that the memo says, if they're going to deny you based on unfavorable discretion, they are legally required to detail and articulate it point by point in the letter of why. And there are, depending on the situation or whoever it is, you still have options to appeal depending on what it is. I'm just saying because, until I see a denial based on that, I can't tell you what it is about your own particular case and what you should be appealing. So, yeah. So again, yes, it is very stressful. It's a very stressful time. But again, faith and fear, it just can't coexist. You got to decide, am I going to be fearful and I'm going to just hole up in my room and cover the closets, for the rest of my life? Because again, you just don't know who's going to be in the next administration. Or you can just, decide, you know what, I trust God. I know I'm eligible for adjustment of status. I know that I cannot consular process because I cannot be away from my family for 10 years. I know that I have not committed any crime. I know that I have a visa ban in my country. I know that I have a visa pause in my country. It's impractical for me to go back there. Then make that argument. All right, guys, I got to go, but I hope you guys have a great week. Schedule a consultation if you want to know about your particular case and how we can assist you. Or if you want to find out if you're eligible for something, we can go over your immigration history and your cycle, here in America to make a determination. Our number again is 678-325-1037 or 678-233-2170. It's in our profile, or you can book your own consultation directly in our profile. The link is in the bio in all the platforms. Okay. All right, guys, have a good one. Bye.